Hello, everybody. H1B, two letters and a number that have suddenly become incredibly important to people who are looking to apply to American business schools or other graduate or undergraduate programs. It could determine whether or not you can stay in America after graduating, or if you have to return to your home country. It could, in a lot of ways, define your professional path. And suddenly that's all been kind of thrown into tumult. Today, on our live version of the GMAT Club podcast, I'm speaking with Adam Cohen of Siska & Susser. He's an expert in immigration law. How are you doing today?
I'm doing quite well, Brian. Thank you so much for having me, and thank you for the GMAT Club team as well for the invite.
Absolutely. And I just want to say before we start that anyone who's watching live who has questions, please drop those in the comments at the end of our conversation. We'll take some time to answer some questions. And along the way, if there are any that are, maybe germane to what we're talking about, we'll throw those in the conversation as well. Before we start, can you tell us a bit about yourself and your practice?
Yeah, sure. Yeah, thank you, Brian. So I'm a partner with Siska & Susser. We're based out of Memphis, Tennessee, and we work with clients all over. So we practice in almost the entirety of US immigration law. My specific focus is with healthcare and academic immigration. So I do a lot of work with doctors and allied health providers, but I also do a lot of work with students and scholars, faculty, researchers. We do a lot of work with entrepreneurs as well. And so, yeah, I'm very pleased to have this conversation with you all. I also put out I should note, an academic immigration handbook. It's now in its 4th edition. It's available on Amazon as well.
All right. So I want to kind of give a big picture so that people understand what's happening. A lot of our listeners, a lot of my clients are people from overseas, not in the United States, who are looking to apply to MBA programs in the United States. And H-1B is not the visa program for people who are looking to come to the United States to learn, right? So that it's not an education visa per se. What is the H-1B visa, and how have the rules around it changed recently?
Yeah, so that's a big question, Brian. So because it requires, first, in terms of the background of it, H-1B has existed in various iterations over time. I think it was first created actually with the Immigration and Nationality Act in 1952, but it is changed over time. It is basically the most common professional work visa in the US immigration system. It is basically, you have to establish that the position requires at least a bachelor's degree in a specific specialty, and you have to show that you meet those minimum requirements for the job. There are different worker protections involved. There are different baseline prevailing wages that need to be paid. And there's also, in many cases, there is a lottery. There's basically, because of how popular it is, there's a lottery for to receive one of possibly 85,000 numbers, slightly reduced by other visa programs, but it's very competitive. It has filled, over the last several years, it is filled every year. In other situations for nonprofits with university affiliations, nonprofit or government research organizations, universities, there are different types of cap exemptions. So there's kind of ways around that cap. That is like we can get more into the details. That's like the very short sort of description of it. Now, ways that it has changed over time, it's certainly, as a lot of things in immigration, it is fairly political, right? In terms of, different administrations certainly affect the policy. So you saw during the first Trump administration, you saw a lot of restriction of H-1Bs, a lot of policies that made H-1Bs a lot more difficult. And you saw a softening of this in the Biden administration. And in the Trump administration, Trump 2.0, we did not see that focus on H-1Bs, at least initially. And a lot of that, I suspect, had to do with Elon Musk. His companies, are very big users of the H-1B program. He had a very prominent role in the administration. There was a lot of warm relationships between the big tech companies and President Trump. And so that was not what we saw initially, although we have seen um, a focus on academia, right? And academic immigration in general, and a lot of students transition to H-1Bs. So that was there. Now we are starting to see a little bit more of that focus on the H-1B, with Elon Musk not really having not having a prominent role in the administration anymore. So it will be interesting to see how it evolves over time. And I know we're talking about this particular proclamation, but I know, Brian, you and I were talking just before this presentation, how there's just so much more that's going on, right? And so there's just certainly a wider context, and looking at this proclamation in a vacuum doesn't give the full picture of what's happening.
And if you are an MBA applicant, why does how MBA or the H-1B is structured, how does that impact you, and when would it start to impact you?
Sure. So, I mean, first off, if you have an MBA, right, so you already have this professional position, right? And the jobs that would be available to someone who has an MBA are going to be professional, positions, right? So by and large, they are going to qualify under the H-1B. Now, I will say there's a little caveat there where in certain situations, if you have sort of what the government would call a general purpose degree, such as just like a bachelor's in business administration, or maybe even an MBA without a particular concentration like management information science or things of that sort, that can cause some issues with the H-1B, but by and large, it is an H-1B position. Mostly when you have someone who has an MBA, they're likely going to be in the private sector. Right. So that means that they are going to have to go through the H-1B lottery, which is very competitive. But because they have an advanced degree, right, a US master's or above, they get to benefit from being put into the master's cap. So they basically get 2 bites of the apple every H-1B season, right? They get to be put into the master's cap first.
There's 2 parts. There's 85,000 total, correct? And 65
right.
is kind of the everybody part, and then, or 650 is, I'm getting my numbers. 65,000 is the everybody with a bachelor's, and then 20,000 is the specialty portion that you're talking about, correct?
That's right. And that was last changed, I believe it was in 2004. And that's really the last time there have been very strong, meaningful updates to the H-1B, right? And what do we know from this? Like I'll frequently say, like, Tesla hadn't even started, YouTube was just barely beginning, right? I think the iPhone wasn't even in development yet, right? So it's a system that sorely needs updates, right? To be responsive to the economic need of this country, shortage in this country, a need to revitalize the economy, right? And have startup businesses and encourage entrepreneurs and all of that as well, right? But yes, to your point, 65,000 is that bachelor's cap. It is reduced slightly by H-1B1 numbers, which are visas for similar type visas, but they're for Chileans and Singaporean nationals. So there's a little bit of a reduction, but it's mostly 65,000, and then the 20,000 are for those who have advanced degrees. And some years ago, they reversed how they ran the cap. So they used to run it, I want to say it was the 20,000 first, and then they would run the 65,000. And now they run it in reverse order, which means that you have more saturation of master's degree and above holders at the time that the 65,000 is run, right? Because they have not been siphoned out in that master's cap. So the percentages of those with advanced degrees has increased, right? It's not as great for those who have just the bachelor's degree, but for those who have an MBA, those advanced degrees, there's more likelihood of them being selected, but it's still very competitive.
So you mentioned that some MBAs might end up being in the general category. Would that mean that someone who's applying to an MBA should think about maybe a program with something like a STEM designation or something like that in order to ensure that they get put in, or that they're categorized in among that group that gets the 2 bites at the apple?
Well, just by virtue of having graduated with that MBA, they can get those 2 bites at the apple.
Okay.
However, Brian, to your point, if they have some type of degree that is a STEM degree, they may get even more bites of the apple, right? And what I mean by this is after one graduates, right? So you have like an F1 status, let's say, that's your student visa, and you're doing your MBA program. After you graduate, you get 12 months of optional practical training. That's available basically to almost all F1 students. And then for those who either have a science, technology, engineering, mathematics degree presently, or in certain cases, like, for those who have an MBA, it's not really like a STEM degree, but they might have had a prior engineering degree or something where they never made use of that STEM OPT, and they might be able to recapture that, that unused STEM extension. But essentially, they can possibly take the OPT from 12 months to 36 months. And imagine if you have an employer that puts you in a lottery every single year, that gives a lot of different opportunities, right? And that's like 2 times each season, right? So it could be 6 or more, possibly bites of the apple.
So just to flesh that out a bit, let's say that I'm in my last year at Ross, right? Finishing my MBA. I would have access to OPT, which is like basically a year to get a job or a position where my immigration status is solid. If I'd had a STEM designation, it's 3 years. I would probably have a position at graduation. Sometimes it takes a bit longer. Mm-hmm. But while I'm on OPT, my employer could then begin applying for H1B on my behalf. And if it's 3 years, you're saying that during those 3 years, I would basically have 2 times per year where I'd be in the lottery. And so the chances that I would be able to stay on an H-1B would be much increased by virtue of that.
Right. Essentially, yes, that is true. I would note that the student does need to be able to work or train, right, during that OPT and that STEM OPT period, right? So it's not just you kind of hang out here, but you need to be engaging in actual practical training that is directly related to your course of study. And there are unemployment allowances, I guess you could say, right? If you don't have a job within, the first 90 days, right, for regular post-completion OPT, that's okay. But you need to make sure that you have work for the rest of that period, right? So there are these unemployment limits. But yes, I mean, assuming somebody who, student who is engaging in that practical training all along, they are in a valid status. They're able to work and to train, and their employer that they may be already training with that employer, right? That employer wants them, really thinks that they're great performers and is putting them in the lottery every single year. And I should note too that, some years back, they kind of bifurcated this system of the H-1B lottery into a registration period and the substantive filing of the H-1B, which actually helped a lot because there's less barriers to entry into the lottery, right? The costs are lower. There's not as much, substantive material that needs to go into that registration. And they've also rectified some of the abuse issues that were happening with that registration system very recently. So it's actually a better system than it was before. So a lot of times it makes sense to just enter into the lottery as many times as one can. I also don't want to forget the piece about talking about MBAs, right? Many of them will move into their own positions as well, right? And so, or form their own companies, right? The next great companies. So it works a little bit differently for them. They have a lot of ability with respect to regular post-completion OPT to be able to sort of build that company. It gets more constrained with STEM OPT, but there are certainly possibilities with that. And then they can also petition or have their entity petition them for H-1B status. That's always been, somewhat difficult. There's been an opening up of that. And then even most recently with the Biden administration, their modernization regulation just before the administration ended has opened up the possibilities of entrepreneurial H-1Bs even more.
Okay. So then one of the things that you're talking about there is if I start Phobitech, my LLC or whatever could petition. All right. So that then kind of
Right,
transitions into kind of the atomic bomb that blew up, right? Which is this $100,000 number.
I
It's
don't
a
know
thing
what you mean, Brian.
yeah, so your life has been completely unaffected.
Yeah.
And everyone kind of freaked out about it.
Mhm.
So explain it. Who's paying it? How does it change the nature of who can get an H-1B?
Yeah.
Like, what did that executive order? Because it did come through an executive order, correct? How
It
did
did,
that?
yeah, like a proclamation. Yes,
Okay.
exactly. Yeah, so I guess I'll start with a little bit of a timeline, right? Because I think that might be helpful. So it started on I think it was September 19th that this proclamation came. It's called Restriction on Entry of Certain Non-Immigrant Workers. It came as a Friday surprise. So what I mean by Friday surprise is, a lot of us in immigration attorneys, we are familiar, especially with the first Trump administration, that these things, you'd be just getting ready to go on the, rest in the weekend. And like that evening, Friday evening, or Friday afternoon, something big comes out that's going to like upend the immigration system. So this was another one of these Friday surprises. And, it's interesting because it is basically almost formed as like a travel ban in a sense, right? It is restricting the entry into the US of US workers. It's very akin to all of these other, Trump 1.0 and 2.0 travel bans. It uses the same authority of the president to restrict the entry of non-immigrants. So it was, conditioning it basically on this payment of $100,000, and it was to go into effect in, 3 days, I think, from that proclamation, right? So not a lot of time, and everyone was panicking, of course, right? Our firm, we sent out like several client alerts. We did a live stream about this, right? Because we wanted to get information out to our clients that do not travel, because we didn't know what this meant, right? Cancel your travel plans. And if you are outside the US, come back immediately, right? That's kind of what the messaging was, because it was all related to this restriction of entry. The Commerce Secretary said it was going to be $100,000 per year as the fee originally, and then that was later clarified. So everyone's panicking, and then there's basically this walk back that happens. And it's interesting because the walk back made it even more confusing, I would say, right? So then there was a statement from the press secretary about it only applying to new visas, not renewals, and that it would first apply in the upcoming lottery cycle. Okay, so it looked like it was just for H-1B lottery, and it's just for these renewals. But again, even renewals, and this was echoed in subsequent guidance by other government agencies, renewals are not an H-1B term of art. So we have no idea what that means. That extensions, amendments, changes of employer, changes of status, right? There's just a lot of confusion around that. And then it also mentioned in certain statements, like from Customs and Border Protection that came out, it said that it was for individuals outside the US only. But that is not what US Citizenship and Immigration Services said, or Department of State. And there was a thought that maybe it only applies to H-1B lotteries. That's what the press secretary said. But then USCIS said that it involves those who I'm trying to think. It was one of these statements. Was it USCIS or was it CBP? Oh, it was DOS actually. It was Department of State that said it includes the lottery and any other H-1B petition submitted after September 21st. We still don't really have clarity around it, so it was like confusion over, do you need to be inside the US or outside the US? Are these affecting lottery petitions or all petitions? What is a renewal? What do they mean by that, right? Is it a $100,000 one time, or is it per year? And then they had this national interest exemption provision that was in the proclamation as well, where they said that they might be able to have certain carve-outs in the discretion of the Secretary of Department of Homeland Security, but there were no parameters provided to that. So we have filed a bunch of H-1Bs with national interest arguments, right? But we don't have any protocol for it. We're just kind of, just trying to argue as best we can that the work that the individual is doing is in the national interest. So that's kind of where we stand. And I'll just say too that anecdotally, we are still seeing changes of status get approved. We are still seeing changes of employer getting approved. And I don't know what that means altogether. I think a lot of it probably relates to lack of guidance for USCIS as of now. And I also think that it relates to there not being a mechanism in terms of collecting this $100,000 fee. The other thing that's so confusing, right, is that, we're talking about a travel ban, right? So that's something that would restrict the entry, and maybe the payment would have to go to Department of State at the time that they apply for the visa. But a lot of the other guidance from the agencies is basically saying that it affects the petitions, and one has to pay the $100,000 to the petition. So in what way, if we're filing petitions stateside with USCIS, how is that related at all to the president's, authority to have travel restrictions or restrictions on those coming into the U.S.? So it's just been a mess in the way that it is unfolded. And there's certainly, and we can get into this, right, but a lack of consideration of the effect that it will have in different industries.
Let me ask you an incredibly basic question. Has anyone actually written or sent a check for $100,000 yet? Has that happened as a practical matter, or is it supposed to have happened?
Not that I've seen. I've not heard of anybody actually paying this $100,000 fee as of yet. I think a lot of people are just trying to figure out, how this would work and how they would request the fee and that sort of thing, right? But we're still early into this, but there were a lot of filings like right after the H-1B proclamation took effect, and we're only sort of learning now. If you have gone through just sort of logistically, right, an immigration attorney is working with their corporate clients, their business clients and everything, and they've kind of worked out everything. And now they say, now it's said, okay, you have to suddenly put up this $100,000. Like, that's something that most businesses would pause over and say, well, we need to talk about this. We need to sort this out. We need to have internal communications, right? So it's like nobody was ready day one to start paying $100,000, right? Because it was, certainly nothing expected. So I have not seen that. And I think most immigration attorneys are really just filing business as usual, or they're putting in national interest arguments, things of that sort.
And in theory, how it's supposed to have worked, and correct me if I'm wrong, or clarify, is that if I'm, again, put me back as, I'm going to graduate Ross here in a couple of months, and I get a job offer from Amazon would be the one to sponsor my H-1B, and with the successful completion. So if my number gets selected, then they would send probably a wire transfer check or whatever to government agency X as part of the process. Brian Phoebe, would never have to get out my Bank of America card and, put $100,000 charge. Is that correct?
Right. And yes, I think that is correct. It would probably be something that, once the person got selected in the lottery and they're filing the substantive petition, the $100,000 fee would have to be paid by the employer. It's a little bit, it's interesting. It's an interesting question, right? Because we know that the employer has to pay all of the H-1B legal and filing fees by Department of Labor regulation. This is sort of this new proclamation. It's not really clear even what it's attached to and under what authority the Trump administration can issue such a fee, right? So it's a little bit more unclear, but I would take sort of from a conservative tact that would probably have to be paid by the employer. And I think kind of realistically we can figure, right, that a a lot of individuals who are going through like the H-1B lottery, for example, they don't have the money to start paying $100,000. Many of the companies don't have that kind of money to do that either.
And just to get a sense of the scale, was it like $650 before, something like that?
Well, it depends very much on the, whether we're talking about a cap exempt entity, whether we're talking about, how large the company is altogether. So I think you could see, just depending on the size of it, it could be, and whether they filed before, it could be something like akin to the fee that you're mentioning, really up to maybe, $2,000-$3,000. And then if you add in government expedited processing, like premium processing, then you're looking at, another $2,805. So it wasn't a super small fee in and of itself, but, we're looking at something more like $5,000 versus $100,000.
And again, thinking about this from the perspective of someone who is either going to apply for an MBA or is currently completing their MBA,
right?
Supposing, and we'll talk about the suit in a second, but supposing that it goes through in what you might consider the fullest deployment of the proclamation, right? How do you think it changes who is going to be offering H-1Bs? And also, if you can also say something about people who are looking to do MBAs with an eye on an entrepreneurial venture, like how those things come out in the wash with the new full deployment of these as yet unsettled rules.
Absolutely. Yeah, Brian, that's a really good question too, because I think that, it definitely affects different entities in different ways, right? So if we are looking at, I think maybe it's geography, it's the type of entity, and then, as you mentioned, right, it has to do with sort of the entrepreneurs as well, right? So geographically, we know that, if we're talking about maybe like rural companies versus like urban, right? I think that there's sort of a difference between the companies in terms of, profits, in terms of like what Silicon Valley can handle versus, other states, right? Maybe states in the Midwest, especially where they really do need a lot of revitalization in particular areas, right? So I think that definitely comes into play. I would say probably even more specifically, like the different types of entities, right? Like what nonprofits are able to handle, maybe small to mid-sized universities, small businesses, what they can handle versus the Amazons, the Facebooks, or Meta, I should say, the Metas, the Teslas, right? What they can handle. So I think that definitely makes a big difference. And then I think in the entrepreneurial context, what type of venture capital does the company have, right? If they have substantial venture capital, it's probably no big deal, in a sense, to pay this $100,000 fee. But it really depends on how the company is capitalized in terms of what they're able to do. But I think those are probably, the biggest considerations. It's not so much the degree or the qualifications of the particular individual. It's really I guess you would say it's just the financial and status of the petitioner, whether it's, big company, a small business, or a startup.
Okay. I want to talk about the lawsuit that you bring, but I want to do
Sure.
a quick nod towards some of the questions that are here. So if we can talk out some of those. So Shailesh Rawat asks, are there recommended alternative visa routes, O1, TN, L1, et cetera, that MBA grads should start preparing for early?
Sure. Yeah. So, I mean, that's a great question, right? And a lot of times when I have these presentations with universities, we'll talk about the H-1Bs, right? But then we'll also talk about different types of alternative statuses as well, right? Not just because of this $100,000 fee, but just because H-1Bs are competitive. So it's always good to know of different ways, alternatives, right? So I would say, O1 is an extraordinary ability status. That is oftentimes a really good alternative for those who qualify. So we've done them for entrepreneurs, for example, right, who are building up that company. They have a lot of venture capital, right? That shows that, you have angel investors or other companies that are putting their full faith and credit in that company. That means a lot. So the valuation of the company can be helpful. And a lot of them are, serial entrepreneurs, right? They may have already had certain types of ventures already that were successful. So that can be used to help meet that extraordinary ability standard. There are TNs. Now, TNs they don't work quite as well for entrepreneurs because there's not really supposed to be that self-employment element, right? But for those who are going to be working for an employer, there are management consultants. There's various ones, right? Because we know that you could be taking that business degree and you could be going into a lot of different industries and fields, right? They have healthcare positions. They have a lot of science positions. They have a lot of instructor positions. And then they have other things like engineers, for example. So a TN could be workable. Now that's for Canadian or Mexican citizens, right? So it is a little bit restricted in that sense. There's H-1Bs, as I was mentioning, or H-1B ones. Actually, it's not clear whether this proclamation applies to H-1B ones. That's not entirely clear, but those are for Chilean and Singaporean nationals. There are E3s that are very similar to H-1Bs. Those are for Australian nationals. There's also E2s, which are very popular with entrepreneurs. It's basically a treaty investor visa. So it does depend on whether the country has a treaty of commerce with the US. India does not have that, but there are a lot of other countries that do have a treaty of commerce. And L1s that's another big one where somebody is working for an entity abroad. Like let's say it's a multinational company and they work for 1 year at the entity abroad and then they get transferred in to work for the US entity. So it's hard to say like, how do you plan for each of these in advance? But there's just sort of a very brief primer of different types of alternative statuses.
Okay. This one is probably more straightforward. Will my $100,000, apologies if you hear my dog barking, he's upset.
Oh, no. No
will $100,000 be applied to F1 students as well? We will be within the country and just change our status from F1 to H1B. Will the 100,000 still apply to us?
Yeah, likely so. Likely so, but again, it's not entirely clear. I think it is the fact of applying, regardless of what status you have presently, right? It is the fact of applying for that H-1B petition that makes someone subject to that $100,000. And again, they've only carved out renewals. So what exactly does a renewal mean, right? Does it mean an extension or does it mean something else?
Sorry, there's a delivery man, dog, everything's going crazy in the background.
That's okay. No worries.
All right. One more question. If you were advising an international MBA candidate deciding between United States and Europe, who holds degree admits from both, what would you tell them right now? So this is kind of like more of a maybe partly legal, but also kind of an interpersonal bit of advice that you might give someone given what you know about the landscape.
Yeah, and it's hard to answer because I don't claim to be an immigration specialist when it comes to immigration or immigration to other countries, right? Within the European Union. So obviously they each have their own immigration systems as well. And a lot of them are undergoing their own type of restrictionism as well, right? So it's not like US is the only restrictive country and the other ones are very open in terms of immigration, right? There's a lot of variation among different countries. So I don't want to summarize, what's happening immigration wise in every, EU or other country in Europe, right? But I would say it's just, I still like, it to be that your career, your prospects, where you want to live dictates more so where you will be than the immigration system. because there are different options, not always options, but there can be options, to be able to immigrate to the U.S. and to be able to study and to work in the U.S.
All right. And one last question before we talk about your litigation for a bit.
Sure.
This is sort of a specific case, but it does tie into what you were talking about with advising people not to leave the country. And there was kind of these dramatic scenes that people might have seen where people were getting off of airplanes. I think there was one at SFO on a plane bound for India. And it was like, they were getting calls like, get off the plane, because, and maybe you can explain why you're better to remain in the United States or to, be here for this process. It says, anyway, the question is, as someone who got their H-1B in 2023 and recently quit their job in the US and returned to my home country and hope to return for my MBA next year, would I be able to hop back onto H-1B if I get hired?
Yeah. Recently quit. Yeah. So I think that, the short answer to that is yes. There are, a certain amount of caveats to that, right? One of them is, well, you indicate, the question asker indicated that he would be hired, right? So like, that's the one thing is have the employer. I think whether one is subject to the cap or not subject to the cap, I think that sort of depends. And it also depends on whether the individual is hoping to get a full new set of 6 years. Because I believe, I don't come across this issue too often, but I believe if you are getting a new set of 6 years, you kind of need to get counted again, right? It's not like coming for the remainder of that H-1B time at that point. Whether the $100,000 fee will apply, I think that it could. Does a renewal include someone who had H-1B left and is now trying to come back in H-1B? I don't think, in my impression, probably renewal is more constrained than that. And so that fee might apply. But again, there's just not a lot of guidance on these different scenarios, whether it is, that it is with a lack of awareness of these different scenarios, and that's what the administration has, or whether they are anticipating that, this litigation is going to be successful and they're not really wanting to spend a lot of time or resources on this fee. That could be another thing that sort of explains this quiet that we're experiencing, a lack of clarification. But I think it's not entirely clear at this point.
And I think that's kind of, I mentioned to you before, I think before we started recording that, we've done a couple of these events over the summer, and kind of the prevailing, theme or idea was, I don't know, but here's my best guess. And like, there's a lot of this that kind of happens, that's happening this year with students where they're trying to figure out, some of it's reading tea leaves, some of it's actually trying to understand policies. This is also an issue for people simply deciding, like, there are different visa and national restrictions just to come to the United States. There was concerns about safety of students, et cetera, et cetera. And so one of the reasons I do want to talk about your litigation is I think that it does play a part, if for lack of a better phrase, I guess, in like the game theory of figuring out, like, what am I going to be facing? So can you say a bit about the litigation? It's a coalition of immigration lawyers, if I'm correct, and you can please clarify for me. Like, what is the basis of the challenge? And what do you, and I know it's super hard to predict both what courts will say and timelines, but what do you imagine the timeline for a decision up or down on this case would be?
Yeah. So let's talk about this a little bit. Let me just say, broadly speaking, I think we have to understand that the Trump administration, they have different policies that they want to bring into effect. And it takes time to do that, right? If you have a lot of things that you want to do and you have 4 years in which to do it, sometimes you try to streamline things as much as possible, right? Because a lot of times, things need to be addressed in statute, and Congress is not moving very well in the immigration space, right? Some of it takes long rulemaking that could take, a year or more. to materialize. So a lot of this are kind of darts at a dartboard is the way I explain it to clients, right? It's like just trying to see what sticks. And a lot of the, some of the litigation work that we and other, firms are doing is to just kind of swat some of the most egregious ones out of the air, right? Before they land on the dartboard. We're just trying to stop some of the biggest, most destructive types of policies from coming into fruition. So our impact litigation group, it basically started during the first Trump administration because we really had to pivot to litigation with a lot of these very, very damaging, decades upending types of policies. And it's our firm, Siska and Susser. It's also Cook and Baxter in Atlanta. It's Bless Litigation, Jesse Bless's law firm, and it's Joseph and Hall that's in Denver, Colorado. That's our firm. We've done different types of litigation over time. Earlier this year we had some challenges with termination of student records, and we were able to help along with other firms that were filing lawsuits nationwide. Right, that policy got beat back pretty well. This time, it wasn't just impact litigation. It wasn't just our collaborative. It was also Justice Action Center, Democracy Forward Foundation, and South Asian American Justice Collaborative. So I just want to make it clear that it was like a really good effort of a lot of people who took this on without it charging any fees to just eliminate this policy altogether. It was filed in the US District Court for the Northern District of California. And, there's a wide swath of plaintiffs that are involved, right? Labor unions, there's a union related to, for interns and medical residents. There's an organization for university professors. A lot of religious organizations are involved as well, because it has a big impact on on the religious sector as well, on churches, et cetera. So it is, it's just basically this big action that was filed very recently. In terms of, Brian, did you ask about sort of kind of what the basis of the litigation was?
Yeah.
I want to make sure I'm addressing your question on that. So, the basis of it is that the imposition of this proclamation was unlawful, right? As I said before, it's, just kind of pushing out certain policies to try to make them effective by any way necessary as quickly as possible, right? Because there's so many things that the administration wants to accomplish. So here we basically just have a signing of a piece of paper and the thing is that there is a statutory structure already for the H-1Bs. This is imposing these fees and taxes and things of that sort. And that is also within the jurisdiction of Congress, right? We have separation of branches of government. The power of the purse is controlled by Congress. The other thing is it creates this legislative rule, essentially, and it hasn't even gone through Administrative Procedure Act rulemaking. This is a process that is designed to allow for the public to be involved and engaged in that rulemaking. And so this was a signing of a piece of paper and effective 36 hours later versus the APA rulemaking, which is you give this proposed rule, you put it out there, it goes through Office of Management and Budget, economic analysis, and then it gets vetted to the public so that the public can provide commentary, help the administration understand what the impacts would be. Different industries get to weigh in on what those effects would be. And, we have another duration of status change with student visas. There were, thousands upon thousands of comments that were provided to this rule that now the administration has to sort through, and they have to provide meaningful commentary to those, right? So this was done without any of that. Now, there is such a thing as interim final rules in rulemaking. This is not that, by the way. This is even less than that. But interim final rules, you have to provide good cause for why the rule is going into effect immediately without going through that public vetting first, right? So those are making sure I'm kind of getting to all of those. Those are really all of the particular issues, right? And I'll just say even more specifically, there's nothing in there. It's like this broad criticism of the H-1B process and fraud inherent in it and things of that sort, right? But there is no consideration of the effect it would have on small businesses and nonprofits and the ability to pay those fees. There's no distinguishing between those different entities in terms of what fees are provided. It's just a flat 100,000 across the board. It doesn't talk about any alternative ways to address the problems that they see. And yeah, I mean, I think that just like we had with the duration of status final rule, it is, or proposed rule on the student side, they put forth these really small types of issues and things of that sort. And there's a lot of other alternative means to address very small pinpointed problems versus this broad brush approach that completely upends an entire structure, right? So this is just upending it without, focused ways to address the issue. And the final thing I'll say about it is that, as I mentioned early on with the statutory structure, there are already worker protections built in. You cannot adversely affect working conditions for U.S. workers. There are prevailing wage baseline wage payments so that there's no exploitation of workers. There are provisions for site visits and wage and hour, and also USCIS fraud detection site visits. There is a policy that the Trump administration is already putting out there called Project Firewall, which is going to be doing a lot more work in the H-1B compliance domain. So any perceived issues they have, there are already protections and they're already doing other things. So it's really confusing why this is even coming to fruition, and the way in which it's happening is unlawful.
And the timeline, so you're in district court, would be you're looking for a restraining order, I presume?
Yeah, right. So injunctive relief.
And then ostensibly perhaps the Supreme Court is sort of
possibly, yeah. If it was taken up, sure. It would go district to Circuit Court of Appeals to possibly to Supreme Court. But it's something where it might, it might end up receiving some type of injunctive relief early on, even while the merits are being decided. So, we'll kind of see how that progresses. I'm also not sure whether, some of this could be like the shutdown that might ultimately affect the federal courts as well, and kind of make things take longer to play out.
And there's a question here that I guess sort of touches on it. I'll provide something of an answer, and then if you have some clarification or some additional things.
Sure.
Alvaro asks, how do you think the United States MBA universities will respond to this H-1B change? Any change in tuition fee as ROI will be dramatically affected for appliers. And so the basic idea here is that if it's harder for an MBA student to get a job, part of what MBA admissions care about is that they're producing people who are go into the workforce, are successful, who thrive, and that is part of their ROI consideration. That is true as a general matter. And I think that this is if this persists for several years type of thing, might be, but I would doubt that MBA admissions committees this year or even next year are really taking this into consideration for a couple of reasons. One, admissions committees tend to be small c conservative in the sense that they measure twice, cut once. Sort of thing. And so we've seen this with a lot of things within the admissions world. Only this year are a lot of MBA admissions committees, do they have policies on the use of AI, for instance? This is they could have had a policy last year. They said, let's wait and see, right? There's just not data on it. And so, I asked you before, has anyone actually sent a $100,000 check? And it was not yet. So we don't know, right? I think that you've given great insightful and educational insights or thoughts on what's going to happen or what could happen, but it's also the case that these schools don't know yet, And so my guess is that in terms of admission, that they're not having those discussions explicitly yet this year. And I would doubt next year either. I don't know if you have additional thoughts on that.
Yeah, I mean, that makes sense to me too. I mean, it does certainly takes time for big universities really to change. There's a lot of other considerations, even apart from the immigration aspect, right? That they have to contend with. I will say that, universities are responding in different ways to other types of policies and things that are happening, right? So for example, a lot of the social media vetting and fears and concerns over students acquiring their F1 visas from abroad. A lot of campuses are, they're starting to rely more on international partners where students can go and sort of this relationship, right? Like they might study at another university, but receive credit toward the U.S. degree while they're not able to come into the U.S. Or just having more flexibility, delayed starts and things of that sort for the course of study. So there are different ways that universities may adapt, but I think right now, especially with the uncertainty over to whom it applies, and then with this litigation in the background as well, it might be premature to come up with more lasting policies on it.
Let me ask one more question here from from Pooja, who says, could you clarify for me the F1 visa requirements regarding the OPT STEM period? Specifically, when we're in this period, can we travel outside the United States?
Oh, yeah. So this is a question that I get a lot about traveling during the OPT period. Typically, when one actually has their optional practical training or their STEM OPT, they are able to travel, but it's best if they already have an employer at that time. And then they can also show, provide pay stubs, and they can show that they're already engaged in this training versus somebody who, either it is pending application for OPT or STEM OPT, or they're in a period of unemployment and they don't yet have that employer. So it's something I don't want to give too broad based. And of course, this isn't legal advice, we're just trying to answer these more in sort of a hypothetical. But oftentimes it depends on exactly where the student is in the timing aspect and whether they actually have a job in terms of the comfort level I would have with that student traveling during those periods.
All right. And Killian asks, Adam, it would be great if you could also share some perspective on how you think employers might respond or already making changes to their hiring policies with respect to hiring F1 students. I guess the background is, in theory, part of Trump's theory of the case was that they want more of these jobs to go to Americans. So I don't know if that's in fact actually going to be or has been the case. There's also, I guess, the component of what it means for starting salaries if it costs $100,000, presumably one time, but maybe more. So I don't know if you have insights or thoughts on that.
Yeah. And I mean, I think I would say similarly to what you were saying about the universities and the MBA programs, Brian, I think that, it's so new. And, a lot of companies they're larger companies and they're trying to figure out what this means for them in the long term, right? Because there's not just this 100K rule. Many of you may be familiar that there's a proposed rule out there that would start providing this like weighted selection for the lottery based on whether somebody's receiving a level 4 prevailing wage versus level 3 versus level 2 versus level 1, right? And the weighted selection may mean that people who are receiving higher wages relative to their position and geography may have more opportunities to receive a cap subject H-1B lottery. That is still in a proposed rule format. Comments are still being accepted, and I definitely encourage individuals, certainly to comment and employers to comment on that rule. But I think that that's another thing that companies are going to need to dwell on should that become a final rule. in terms of how they're going to handle that. I would imagine that they may think more about possibilities for alternative statuses, right? As one of the individuals in the audience was asking about earlier, thinking about those types of alternatives, maybe even starting green card processes earlier and try to get those finalized. Although we know that it depends on green card backlogs a lot of times as well, in terms of the timing of the green card process and how quickly it can be finalized. So I think there's going to be a lot of looking at that. And, I'm certainly encouraging employers to just really get engaged in the advocacy around this issue. So it's not even just the advocacy, which is certainly one thing. There's also media campaigns. I know, organizations that are involved in, really trying to bring this to the attention of the media. And then we also have, different organizations and labor unions that are involved in litigation, as we're seeing with this current lawsuit as well. So those are a lot of the things that employers can do as well.
All right. And so our last question from the audience will be from Shailesh Rawat, who asks, what are some smart steps to start visa risk diversification even before joining a U.S. program? So I guess this is maybe kind of a broader question about visa strategy and how to approach it as you're planning to come to the United States.
Right. I would say that's a great question. And it really does depend on the person's individual circumstances and whether they might qualify for some alternative status. I know a lot of students, and this is not even just related to this 100K fee rule, but they try to position themselves the best way they can in the H-1B lottery by, if they have a bachelor's degree, they might go back to school. And it does a few things, right? It gives them extra time to kind of get past this period of restrictionism that we're facing. It positions them better for the master's cap. It gives them, as we were discussing, more bites at the apple. If they have an employer who's even willing to file for them while they are pursuing that advanced degree and into their OPT, they may, look into STEM degrees. And those are different things. They may also, I guess, digging a little bit more into the alternatives, right? If they have a prospective employer that is a multinational company, maybe looking at, well, what are the possibilities if I were to work in office abroad, right, for a year and then maybe transfer back in with an L1 status. And there's other things that people will do as well to try to get around the competitive lottery that might be relevant here. Sometimes people will work remotely from another country for a certain period of time. There's some other companies where they help facilitate cap-exempt H-1B filings using arrangements and relationships that universities have with certain private companies. So there are different possible strategies just depending on the circumstances for the particular individual.
All right. This has been really fantastic. A lot of useful and actionable information for people who are concerned or just interested in how to navigate this H-1B process. And I guess the final question here is,
Sure.
How can someone who's applying sort of keep abreast of these issues and make sure they don't miss something along the way? And related to that, if they want to get in contact with you or your firm, what's the best way for people who are looking for immigration help to do that?
Sure, absolutely. Well, thank you so much, Brian. Yeah, this has been a great conversation. And I guess a couple things that I would recommend, obviously just, of course, staying tuned to the news and kind of looking at different types of, immigration updates for your particular industry is always helpful. I will say our firm does a live stream every Wednesday evening. We do it through our social media channels. And we're not just talking about MBAs or, specifically healthcare or specifically academia. We're talking about like the immigration news of the week. So it's just a good way to get a general knowledge of different things that are changing. And it's kind of a rotating cast of us, basically. But I try to jump on when there's any, academic related policies or changes or things of that sort. In terms of getting in touch with us, so our website is www.visalaw.com. And I will say that if you get onto our main page, the top right, there is a link to schedule a consultation, and you can see all of our nice pictures and you can see our areas of focus as well. So it really depends on what your particular question is. In certain cases, I might be the right one to talk to you if it's related to student issues, or it's related to healthcare, or it's related to faculty or OPT questions. Like I can help with a lot of that, general business questions. But we also have, for those entrepreneurs, we have another attorney, Jason Susser, at our office who does a lot of startup work. So we have attorneys who are involved in different areas of U.S. immigration, right, with focuses on different types of industries as well. So, if you all have any particular question about that in terms of maybe who's the right attorney, you can feel free to reach out to me. My email is acohen@visalaw.com. You can also find me on the website as well, so you can find that contact information. But thank you all so much. Thanks for having me, Brian. And thank you, everyone who listened in and for your engaging questions.
Yeah, I want to thank everyone who showed up. And Adam Cohen, once again, thank you for spending this hour with us. I'm Brian Phobie with GuruFi.com, and this has been a GMAT Club live event. I will hope to see you guys soon on the next one.